Is a landlord liable under negligence if a murderer gets into a building through an unlockable front door? To find out, you have to read Scurry versus New York City Housing Authority, but it's 15 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of Scurry versus New York City Housing Authority and Murphy versus New York City Housing Authority, two companion cases, published by the New York Court of Appeals on May 23rd of 2023. The citation for this case is 2023 New York Slip Opinion 02752, and the issue in this case is whether a landlord is liable for negligence for having a broken door if it allows a murderer to get inside and attack and kill a tenant. To appreciate what's going on in this case and the context, you have to understand the law of negligence, a little bit about that. Negligence is a tort. It's a civil action where it is alleged that the person had a duty, a breach, a causation, and a damage. That's the elements of negligence: duty, breach, causation, and damage. And the important part, the hardest part sometimes about negligence is the causation part, because causation has two parts. There's causation in fact, and there's proximate cause. Causation in fact is sort of an easy way to think about it. It's the but-for test. It's but for this problem would the harm have resulted, would the injury have happened. But for is easy. The harder part sometimes is the proximate cause. Proximate cause is sometimes called the legal cause. The question here is it foreseeable? Is the injury foreseeable as a result of the defect, of the failure, of the breach of duty in this case? There's a line, and the other thing you have to understand is there's a line of cases out of the first department. The first department, there's 4 departments in New York State. First department's Manhattan and the Bronx. There's a line of cases in the first department that if an assailant engages in a targeted attack in a premises, then there's no liability for having a defective or a defective front door, because it could be presumed that the assailant would have figured out some other way to get at the victim, that the assailant would be so single-minded and focused on that individual that it wasn't sort of a crime of convenience by having an unlocked door, or a broken locked door. It's a crime when there's a targeted offense, that it's a crime directed at that individual, and if it wouldn't happen this way, it would have happened another way. But the second department does not share that line of cases. So what we have in this case, we have two companion cases, and they're both kind of terrible, tragic cases. In the Scurry case, there was a domestic violence situation, and the victim of the domestic violence, the abused individual, went into a housing authority building that had a broken front door. Her abuser, who had previously attacked her on multiple occasions, went to the housing authority building, and because of the broken front door, went into the building and immolated her, set her on fire, and killed her, as well as killing himself, as well as harming a family member, burning them very badly. The estate sued the housing authority for having a broken front door for negligence. What's the other case? Murphy, 18-year-old. So this is now, there's 2 different housing authority buildings, 2 different projects. This is the generic name people call them informally. There's a group of people in 2 different buildings that are having an escalating physical confrontation. And so one night after part of this escalating physical confrontation, the defendant here tries the front door and it's locked, and then goes to a side door of the housing authority building, but it's broken, and goes in and goes up the staircase and finds the victim and shoots the victim 3 times. Now, each of them were targeted attacks. They were the specific bad actor here, the murderer, in each of these cases, was looking for the victim. So what happened is when the estates of these individuals sue the housing authority for having this broken lock mechanism on the front door, the housing authority moved for summary judgment, said, wait a second, there's a proximate cause issue here. That line of cases I mentioned earlier, where if it's a targeted attack, this is called a superseding intervening cause. Yes, there might be a breach of a duty, but this is a superseding event. This is not foreseeable that because there's a broken door, some murderer is going to come in and kill somebody. Now, initially, the 2 different Supreme Courts handled differently. It goes to the Court of Appeals. And here, the answer ultimately from the Court of Appeals is it is not a proximate cause. It should not have been granted. It should go to a jury. That it's possible that it's a superseding intervening cause that would break the causal chain. That's what they say. That's like sort of the vernacular when we talk about causality. Does it break the causal chain? Possibly it is, but foreseeability is the question, and that proximate cause should be a question for the jury. So basically the Court of Appeals says they say it is only where the intervening act is extraordinary under the circumstances and not foreseeable in the normal course of events or independent of or far removed from the defendant's conduct that it may possibly break the causal nexus. But an intervening act may not serve as a superseding cause and relieve an act of responsibility where the risk of the intervening act occurring is the very same risk which renders the actor negligent. So here, the intervening act of a targeted attack is foreseeable. And it's the exact kind of harm that a locked front door is meant to protect. So they say this should not have been granted. It's not as a matter of law a defect of proximate cause. It should go to the jury and let them determine whether there actually is causation in this particular case. And that's the case, the companion cases of Scurry versus New York City Housing Authority and Murphy versus New York City Housing Authority. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.